to allow everyone enough time. Speeders. Okay. Mr. Walsh?
Yes.
Let's go back on the record. And Mr. Walsh, you can proceed.
Thank you, Your Honor. Your Honor, this is Patrick Walsh on behalf of the petitioners to intervene. The intervention in this case is necessitated by two acts committed by the defendants: sweeping statewide mandates and the defendant districts creatively interpreting your TRO of February 4th, 2022. The proposed interveners are children of, or parents of children who are students at defendant school districts. Their children were subjected to quarantines as defined in the Illinois Administrative Code and without due process as required by the Illinois Department of Public Health Act, Section 2305. Intervention is governed by Section 2-408. Intervention is permissible as a matter of right or as a matter of discretion. With respect to intervention as a matter of right, and for purposes of this case, intervention as a matter of right is appropriate when the representation of the applicant's interest by existing parties is or may be inadequate, and the applicant will or may be bound by an order or judgment in the action. Intervention as a matter of discretion for purposes of this case is appropriate when an applicant's claim or defense and the main action have a question of law or fact in common. It has been held that a petitioner must simply have an interest that's greater than the general public's, and Section 408 is to be literally construed. With respect to intervention as a matter of right, the representation by the current parties is inadequate. Inadequacy can be determined where the interest is different between the current parties and those seeking to intervene. In this case, the interests are different because the students are different. Why is that? Well, Mr. DeVore has been representing people from all over the state, and he's been doing an exceptional job. The inadequacy of representation has nothing to do with Mr. DeVore, quite the opposite. The problem occurred shortly after your TRO of February 4th. Certain districts interpreted your order as narrowly as possible. It was our view that your order enjoined school districts and other government defendants from engaging in certain behaviors. Certain districts interpreted that to only apply to the named plaintiffs. So we had school districts with allowing 2 kids to go maskless and the rest of the school had to remain masked. When that happened, the parents, including the petitioners, said, well, what about our kids? How come they're not included in that order? My response was, I think it should be. And they said, well, how do we get protection? I said, well, I think you're going to have to get into the case somehow to ensure that if another order is issued, and potentially an order on the merits, that your kids are protected in case the district defendants or any other defendants try to interpret the order unreasonably narrowly. Now, defense counsel is going to argue that allowing these petitioners to intervene is going to needlessly expand this litigation. But the court should understand that these expansive proceedings were expansive before the petitioners ever sought to get involved in this case. These proceedings were expansive because Governor Pritzker issued sweeping executive orders and mandates and unlawful quarantines that affected almost everyone in this state, rather than giving people due process individually as the Department of Public Health Act requires. Sweeping violations of due process, unfortunately for this courtroom, creates sweeping litigation. So we're here not because we want to expand this litigation, but because we were pushed into a corner. My clients were pushed into a corner by the governor's actions and the defendant district's actions. Now, the second element of that analysis is whether petitioners may be bound by a judgment in this case. Now, there are several scenarios where the petitioners may be bound. And again, it's not will be bound, it's may be bound. If the court finds in favor of the defendants, the petitioners will be subject to that order because they won't be provided with due process going forward. If the court finds in favor of the named plaintiffs, they will also be denied due process and in a way bound by that order. And if the court finds against the defendants and enjoins them, and again, they engage in creative interpretation of your order, they're going to be, well, I guess not bound in that instance, but they're going to be subject to the interpretation of that order. So there are several ways that the petitioners can and likely will be bound by this order. So intervention as a matter of right should be granted respectfully. With respect to intervention as a matter of discretion, if the petitioner's claims and the main action have a question of law or questions of fact in common, intervention is appropriate. Now, the proposed intervener's children are students at the districts, or schools within the defendant's districts. They all challenge the governor's authority to issue executive orders containing quarantines. Obviously, you've been through this many, many times. You understand the issues very well. They've all been subject to quarantines. They've all been subject to masking exclusions, and they all assert that the defendants do not have the authority to quarantine them without due process. So I think here there are questions of law and fact that are really on target. So with that, intervention as a matter of discretion should also be granted, Your Honor. Now, defendants have raised mootness and standing and some other defenses. Our position is that mootness is not an element and standing is not an element of the inquiry into intervention. I guess I'm going to ask for a little bit of guidance here because I know there's a lot on this court's plate today, and I know that there's going to be arguments on the motion to dismiss related to mootness and the same sorts of things. The reason I say that is because if this court doesn't believe that mootness or standing is an element of the intervention analysis, I won't get into that. If the court is going to look at mootness and standing in those things, then I will address that. But
well, I think I would like you to address that
Okay.
because, I mean, a question that's revolving in my mind is, you know, there has to be a case of controversy for you to intervene in.
Sure.
So if defendants are successful on their arguments, so
yes.
while we're here, go ahead
Okay.
and address
Thank
it.
you, Your Honor. I think you put it very succinctly that if there's a case for controversy, then potentially intervention is appropriate. If there is no case for controversy, it's not appropriate. I think we could all agree on that. I think as I sit here today, during this petition, there is a case for controversy. So I think to argue the merits and try to make a finding that the complaint, which isn't even filed yet, is moot, is putting the cart before the horse. I think, with all due respect, that the proper procedure today would be to, if the court is inclined, if we've met the elements of intervention as I discussed, to allow the petition to intervene, and then we're going to essentially adopt the arguments of the plaintiffs in 5002 and maybe add a couple things, but try to ensure that it's not too repetitive. But I think at this stage, it's premature to make a decision on mootness before we're even in the case and we have a complaint on file. That being said, defendants claim that we don't have standing because of mootness. I think standing and mootness are two different things. They're claiming that it's moot because of standing, but at any rate, there is no standing requirement in a petition to intervene. And I think it's, with all due respect, for verbal error to read one into it. With respect to mootness, defendants are arguing that this claim is already moot, although this court has not issued a ruling on the merits on mootness. At any rate, declaratory judgment. For a declaratory judgment, there has to be an actual controversy, and that exists where there is a denial of a right, an assertion of an unfounded claim, the existence of conflicting claims, or uncertainty occasioned by new events. In this case, the petitioner's children have been denied a right. They've been denied due process under the Illinois Department of Public Health Act. The governor continues to assert he has the authority to issue quarantines without due process. Petitioners assert Governor Pritzker does not have a right to issue quarantines without due process. And there's great uncertainty occasioned by the unprecedented issuance of 32 straight disaster proclamations. This meets the existence of conflicting claims element. Now, Governor Pritzker has declared every county in this state to be a disaster in every one of those proclamations, even counties without a single case of COVID. Governor Pritzker has transferred the authority vested in the legislature to his desk by decree. By issuing consecutive disaster proclamations, Governor Pritzker has his finger on the trigger for additional mandates. And I don't think that the governor needs to start pulling the trigger when he has the gun and his hand on it for the court to find that there's a controversy. Now, the public interest exception to mootness applies if the court believes it's moot, which we obviously do not. With the public, to apply the public interest exception, the court needs to find that there's a question of a public nature, that there's a need for an authoritative determination for future guidance of public officers, and that there's a likelihood of future recurrence of the question. Now, courts look to the magnitude of the interests involved for the public interest exception. Years ago, a Supreme Court scholar said there are two types of issues before the United States Supreme Court: abortion and all others. That was to stress the importance of that issue to the people and the court. Since January of 2020, there have been two types of issues in the state of Illinois: mandates and all others. That shows the enormity of this issue. It is without a doubt public in nature. With respect to whether there's an need for an authoritative determination of the question for future guidance, courts look to whether the law is in disarray or whether conflicting precedent exists. I think it's likely undisputed that the law is in disarray. There have been conflicting decisions throughout the state on this subject. And there really is no precedent because, in my understanding, there's been no ruling on the merits on any of these cases. They've only got to the TRO stage. Issues of first impression are appropriate for review under this exception, and cases such as that deal with the liberty interests of minors have been particularly found to be appropriate for this exception, and that's what we have here, the liberty interests of minors at stake. The third element is whether the question is likely to recur. Well, defendants argue in their response that whether mandates are likely to recur is speculative. I would argue it's happening right now. On July 22nd, Governor Pritzker reissued Executive Order 2021-22, which contains vaccination and testing requirements for healthcare workers. He reissued Executive Order 2021-28, which requires vaccination and testing requirements for daycare. So I would argue he's issuing mandates as we speak without due process. So I don't think it's at all speculative. I think it's happening currently, generally. He's exercising the power. It's only a matter of time before he exercises it again against these students. The timing of today's hearing is a little unfortunate. It would have been nice to see what was going to happen on the 15th. But I understand that everyone has busy schedules. But I feel sincerely that we'll be back in here after the 15th sometime when this rears its head again. Now, another element is whether this is capable of, another exception is whether this is the issue is capable of repetition yet evading review. In such a case, the challenged action must be of a duration too short to be fully litigated prior to cessation. Well, in this case, JCAR refused to reinstate the emergency rules before any quarantine case was litigated fully on its merits. So it happened too quickly. The only reported decisions, again, that I'm aware of relate to TROs. Second element is whether there's a reasonable expectation that the same complaining party would be subjected to the same action again. I think I've covered that. I think it's reasonable, at least, to believe that there will be mandates in the future. Quarantines have been issued almost, I think, every month for the last 32 months. It's going to occur in the future. If not for COVID, it could be monkeypox or who knows what else. But, you know, we have, I think, now a state emergency with 600 cases of monkeypox. So I think we need or at least a declared emergency, I should say, not an actual one. But I think the decision is important in this case. Last is the collateral consequences exception to mootness, and that's where a plaintiff has suffered or is threatened with an actual injury, likely to be redressed by a favorable court decision. And I think with what I've already gone over, that we meet that element. So with that,
So my question for you is that, and I noted in your reply that you state that the children are repeatedly being subject to the quarantine without due process of law. And I know that is, we're referring to the Illinois Department of Public Health Act and the procedures that are outlined there.
that's correct.
But we all know that the 4th District has issued opinions that I am bound by. So even though you may feel differently and, you know, maybe that is the correct interpretation, I'm bound by what the 4th District says. So let's say I allow you to intervene and then we file all our motions again and we're here arguing again. I don't know how I could issue another TRO saying that you have to follow the procedures set forth in the Illinois Department of Public Health Act, because I have to follow what the 4th District said.
Understood.
So how are we going to, I guess, how we overcome that is, you know, I issue my ruling and then it goes up on appeal, but I guess that's what I'm struggling with here too. I don't know how we get a different outcome because I'm bound by the 4th
Is
District.
I think that's a vaccination and testing issue, not a school exclusion issue.
True, okay.
So I think
That's right,
we
because I'm thinking
differentiate
of 07 and not of the 02.
Correct.
All right,
so.
okay.
That's what I would argue there. I mean, we're not seeking a TRO here. We're seeking to file a complaint for declaratory judgment. I would, outside of some technical issue, I think that we would be bound by your decision in the current 5002 case. And we're not seeking to relitigate this fully. I think to the extent that the issues are the same. If there's some little procedural hiccup that differentiates the two, which I don't think there are. But I believe that we're bound by your rulings with the current 5002 case.
Okay.
So we're not trying to reopen it and litigate a case parallel to this one. I think we want to be part of it and argue it in tandem.
And then you said that if you were allowed to intervene, you essentially would adopt the position that has already been set forth, but then you might add some new issues. Did I understand that correctly?
Yes, I mean, we'd like to adopt the arguments today of Mr. DeVore and the current 5002 plaintiffs. If there's a comment that we need to make, we'll add it if we think that there's anything that's been missed, which I doubt, but I just want to reserve the ability to add something. But largely, we're going to adopt what they say, so we don't have to argue two motions and have repetitive arguments.
Okay. All right. Thank you.
Thank you, Your Honor.
I was inclined to let the attorney with the most number of clients argue first, but I'm open to suggestions. Mr. Peticchio, I mean, if you want to go first, you can as well.
Doesn't matter to me, Your Honor.
I don't.
Are we still on the motion to intervene, or?
Yes.
Okay.
So, did you game plan for a plan of action? I don't know any proper way to really do it, because I've read the responses and all that, so do we just want to start with the state defendants? And then if the state defendants don't articulate a position by one of your clients, then the other attorneys can stand up and argue? Anyone? I'm open to suggestions. Okay, Mr. Verticchio, you get to go.
Thank you, Your Honor. I will be surprisingly brief and stand on the opposition that the state parties filed and served on July the 20th. First, this notion that, well, the 4th District held that absent an order from IDPH, the procedural protections in the Act don't apply. Everybody agrees with that.
Correct.
And this distinction of, well, that was a testing case. This is a masking case. Frankly, that doesn't even make sense. Either the Act applies or it doesn't. The Fourth District says, absent an order from IDPH, the Act doesn't apply. There's no footnote. But masking may be different. I mean, if there's no order, the Act doesn't apply. So that was really beyond me. Then, other than standing on the opposition, 2 points, Your Honor. This issue about may be or will be subject to the judgment. You've decided this issue when you denied intervention by the teachers' union in January. You concluded, rightfully so at the time, they weren't parties, just as the proposed interveners are not parties. And you wrote, because they're not parties, I'm quoting your order now, quote, a judgment in favor of plaintiffs would have no direct legal consequence for interveners, which is a requirement for intervention, period, close quote. That applies equally today. They are not parties. Any judgment will not have impact upon them. And then the only other point I wanted to make, Your Honor, is I was struck by something Mr. Walsh said. I wrote it down. He said, quote, if there's no case or controversy, intervention is not appropriate. We can all agree on that, close quote. If there's no case or controversy, intervention is not appropriate. We can all agree on that. His papers, the papers filed before you, betray any suggestion of a case or controversy regarding the state parties. His petition to intervene, the first paragraph of the petition to intervene pursuant to 735 ILCS 5/2-408. That's the title of the document filed by Mr. Walsh on May the 12th. First paragraph, after he lists 85 proposed interveners. Quote, pursuant to 735 ILCS 5/2-408, paren A, close paren, and paren B, close paren, petition to intervene in this matter to enjoin the defendants from enforcing unlawful COVID-19 mitigations, period, close quote. There are none. This case and the proposed complaint is about masking and exclusion. There are no masking and exclusion executive order requirements that exist today. So I hold Mr. Walsh at his word. If no case or controversy, intervention is inappropriate. We can all agree on that. Thank you, Judge.
Thank you.
Judge, I just have something quick in terms of the motion to intervene.
Will you-
Melanie Rankin,
Thank you.
on behalf of Homer Community Consolidated School District number 33C, Dietrich Community Unit School District number 30, Central Community Unit School District number 4, Manuka Community High School District number 111, Consolidated High School District number 230, and Illini West School District number 307. I'll get to the merits of the mootness and standing arguments when we go on with the motions to dismiss. My point in the motion to intervene, however, is that the briefing schedule for the motions to dismiss has concluded. Therefore, what I want to ask of the court is that you not consider this motion to intervene in your decision on the motions to dismiss. In other words, to decide not to dismiss it in order to give interveners a chance to respond to our motions to dismiss or to otherwise come in at the 11th hour and create a whole new responsive pleading requirement or anything in that regard. So that's just my request for the court is that you don't let the intervention interfere with your motion to dismiss ruling.
So I guess that would be the question I was gonna propose, hypothetically. If the motion to intervene is allowed, and then, we have the motions to dismiss, and then the motions to dismiss are allowed, are the attorneys of the position that because they are new plaintiffs, your pleadings and motions already would not apply to the new plaintiffs? Mr. Feeney?
Your Honor, we're in a little bit of a unique position. Luke Feeney on behalf of 11 school districts. We filed our motion to dismiss on May 6th.
Right.
We couldn't call that for a hearing because we had to wait on the Supreme Court ruling, so it was before the briefing schedule. I don't believe that any of Mr. Walsh's proposed interveners overlap with any of our school defendants, so
Okay.
we believe we have a right to have a motion to dismiss heard, and would oppose any delay in having the motion heard today.
Okay. Just a second, Mr. Walsh. Go ahead, Mr. Verticchio.
I think, Your Honor, if you look at the proposed complaint of the interveners, you will find that it is in some substance identical to the complaint that's going to be subject to the motion to dismiss. So if that complaint is dismissed, there's nothing to intervene into, and your ruling would apply equally to the proposed complaints. So it's kind of a weird situation,
Yeah.
but at a common sense level, it's not problematic. Because the same ruling will apply to the same proposed complaint.
I think I can answer this, Your Honor, and I hope I'm understanding the inquiry correctly. We're not seeking, if we're granted intervention, we're not seeking to have a whole new briefing schedule on our complaint and do this over again. I think that's what you're asking. We believe that our complaint will rise and fall on the complaint that's in, or the operative complaint 5002 currently. Is that the answer?
That makes it easy.
So then, any arguments with regard to the motion to dismiss today would apply to your client?
That's what I was saying. That's why I said, other than if there's some procedural hiccup, something that's unique to their complaint, but I don't think that exists. I just want to reserve that. But I fully believe that every argument related to the operative pleading currently in 5002 should apply to our pleading if we're allowed to file it in stanter. I'm not looking to do new briefs and do this all over again. I think it should be determined as quickly as possible as well.
Okay,
Thank you.
wonderful. Okay. Anyone else want to reply to the motion to intervene? Can't believe everyone's so quiet. Okay, I want to take just a 5-minute break. I want to step off the bench, and then I will come back and we'll go forward from there, okay?
Your Honor, I'm sorry. I just wanted to reply to their
I'm sorry.
their argument, just
Yes.
very briefly. Sorry.
Go ahead.
I
apologize.
No, it's okay. Very briefly, the 4th District decision that Mr. Verticchio spoke of relates to workplace safety rules, not students, and it's in paragraph 19 of the decision, if you'd like to take a look at that. And also with respect to the actual controversy or case in controversy, I thought that I said actual controversy. Doesn't matter. The case law is the same. It's in our reply. Whether there's a denial of a right, an assertion of an unfounded claim, existence of conflicting claims, which we have here, or the uncertainty occasioned by new events, which would include new guidance issued by the defendants related to the upcoming school year. So I think that we, without any doubt, meet the elements of intervention. Thank you, Your Honor.
Thank you. All right, let's take a 5-minute break. Everyone, if you need to use the restroom or something, do so, and then we'll reconvene, okay?
Thank you.
Thank you.
William Picorni still in here?
Yes.
Got a question.
Yes.
Is it Frankfurt School District 157C or is it Frankfort?
I think it's FORT.
I'm the first part of it. Is it Frankfurt or Frankfort? Is there a Frank? Okay. Your motion is spelled. I thought it was. I had it right on here, but I'm like, crap. Did I do it wrong? Okay. I'm working on cleaning up the docket right now and putting it on there. I get under the time when I'm in your all series to do it. He didn't look that hard, so he was on the. He is on there, so to e-file it. Is 2-615 important? Just wondering as an attorney, is 2-165 motion to dismiss important?
Yes.
All right, so do I need to put 2-165 in the title of it?
615.
615, I need to put that in there? Okay, thanks.
Thank you. No, don't worry about it.
I'll wait till everyone gets back in, so. I'm talking too fast? When they're talking too fast? You just interrupted, yes, because you're the one that has to make the record. Go for it. And I'm sure, we just forget when we're talking, so.
I'm a very fast talker, and I'm
Yes.
gonna go next, so I apologize in advance. Please
He is
do,
very fast.
Please do let me know.
And sometimes he doesn't talk real loud, so.
Yeah. Well, it's up to you. I'm happy to do it. We're only just, I'm only doing movements, so.
That's what I'm doing, same here, same here.
Now, I have printed PDF.
I guess it's a little,
So like printed PDF, and then you can find it.
there's a
on
little more
PDF.
for you to say about how this works, obviously.
Figure that
Yeah.
out.
Right now,
I don't know if you can do PDF, but I can get it so you can, at least, if I can do that. So you can search on the PDF and it goes right to where it is. And then you just have to go to the date on the docket and you have to put them right there.
Yes, that's huge.
I will ask them to see these
Okay.
orders.
Perfect. All right. Do we know, is everyone back? I don't know.
There's 17 of them over there, I counted, Judge. Yep. Tom, you got younger. Better looking, better looking too. I bet.
Just a second, let me reply to this. I was just seeing if anyone else had emailed with regard to this case. Retired Justice Daniel Doyle has passed away from the appellate court, in case anyone is interested.
Which district was he in, Your Honor?
Doesn't say right off the top here, but he's from Rockford, it looks like. So, what district is that?
The second or third? Not sure. Probably the second. No, it could be the first.
It used to be second.
The second.
Now it's third, right? Maybe fourth.
Yeah, they all changed.
Okay.
I lost it.
Okay. So we can go back on the record if you're ready, Madam Court Reporter. Okay. All right, we're back on the record after taking a brief recess, after hearing arguments on the motion to intervene filed by Mr. Walsh and his clients. I understand defendant's arguments as to how the case could be moot, but we have not addressed the motions to dismiss yet. So as the case now stands, there is a case or controversy, so I am going to allow the petition to intervene because, as we have ruled in the past, I think these plaintiffs are different than the teacher interveners, because I felt the teacher interveners were represented adequately by the state defendants. These are individual plaintiffs who would not be bound by a ruling in my case unless they were directly named plaintiffs. So having said that, and Mr. Walsh's representation, his clients are subject to the motions to dismiss that we are arguing today. So I will make a note in the docket entries as well, indicating, because I know it's on the record, but I'll put it in the docket entry, that the arguments today and the pleadings filed by all the defendants are applicable to the new named plaintiffs as well. Anything else to add by anyone to make the record clear?
Only that I brought a proposed order if you'd like to see it in copies, but if you're going to do your own, it's not necessary.
If you would bring it up to me and I'll take a look at it, I'll look at that over the lunch hour, okay? Because I want to get rolling on the motions to dismiss, because I don't know if it'll be as short as the motion to intervene.
Judge, and I didn't state, but I think it was clear that my clients and I had no objection to the request to intervene for what it was worth. I thought it was obvious, but I just wanted to make sure.
Your Honor, can I comment on the proposed order?
Yes.
Given Mr. Walsh's representation relating to the motions to dismiss that are about ready to be argued, I'm a little perplexed by the last line.
Right.
Defendants are granted 28 days to answer or otherwise plead. That should be stricken.
I agree.
If you
And Mr.
could-
DeVore agrees.
If you could email this order to me, Mr. Walsh.
I will.
Later, and I'll correct that line.
If
And I
the-
can put in the order that
Yeah.
the already filed motions to dismiss are applicable to the new named interveners.
Thank you, Your Honor.
Will do.
Okay,
Thank you.
thank you. Oh, yeah, make sure you email it to me in Word.
Will do. Will do. Thank you.
Okay, before we start arguments on the motions to dismiss, I wanted to clarify for the record, because I sent out my chart, but I want to make sure that my chart is correct, that I only have an answer, no, strike that. I only have an entry of appearance from Burbank, number 111, Lombard, number 44. I do not have an answer or a motion to dismiss. Is anyone here on behalf of those schools? Oh.
Good morning, Your Honor. Jennifer Schlentener on behalf of Burbank, 111, and Lombard, 44.
Okay.
Judge, that is accurate. To the extent Your Honor would request a response from us, we would just make an oral motion to join. I'm sorry, what?
Could you just speak up?
Sure. To the extent that if Your Honor would request a response from us today, we would just make an oral motion to join in the pending motions to dismiss. We don't have anything further to add.
Okay. Counsel for plaintiff, any response to her request?
No objection, Judge.
All right, so we will allow you to join in the motions to dismiss. So that is for the Board of Education of Burbank, School District number 111, and Board of Education of Lombard, School District number 44. Then I show an answer filed on behalf of Board of Education of Township Heights, School District 214, and no motion to dismiss. Anyone here on behalf of that school district?
We represent 214, Your Honor, William Corney, and that is correct. There's an answer, not a motion to dismiss.
Okay, and you're not going to file a motion to dismiss, you're resting on the answer?
For the time being, yes, Your Honor.
All right, I just wanted to make sure. Then, Board of Education of Central, CUSD number 300. I only have an entry of appearance. I don't have an answer or a motion to dismiss. Anyone here on behalf of that district? Okay.
Do you know who the attorney of record is?
I don't
I
from
don't
my
either.
chart,
Top of my head, either.
but can you endeavor, the entry of appearance was on January 3rd of 22.
In which district was that? I may know, Your Honor. I may look here.
Board of Education of Central, CUSD 300.
GUSD 300, okay.
While you guys are looking, I'll move on. So then I also have,
Your Honor, just to be clear, that's different than community unit school district 300, correct? I think those are two separate. Lisa Calloway. I think that's possibly a separate defendant.
There's a Rock Ridge Community Unit School District 300, and then there's a Community U School District 300.
yeah, I have Rockridge as separate. And
So
then,
I have a community unit school district 300, which is one of the 30 defendant school districts that we represent. We did file a motion to dismiss. So I just want to make sure that's not who you're referring to.
no, my chart says Central Community Unit School District. Brianna's checking on the clerk system for the entry of appearance.
I'm wondering if that is the erroneous entry of appearance from our firm that was supposed to say Central in number 4, and that we then withdrew, I think it was back in April, to correct it to say number 4. Maybe? Yep, that's it.
All right, so strike that then. All right. Okay, so then I have Board of Education of Woodland Community. I have CCSD number 50. Oh, strike that, wrong one. Board of Education of Lisbon, CCSD number 90. I don't have an answer or a motion to dismiss. Anyone here on behalf of that school?
Your Honor, Robert Swain. Mr. Zukowski, Walter Zukowski, has appeared on behalf of Lisbon. We are in the process of substituting in Mr. Zukowski on behalf of District 90 Lisbon.
Okay.
I don't have that substitution paperwork finalized yet in Mr. Zukowski's office. Our intent on substituting in will be to simply join in our pending motions that we filed on behalf of our other clients.
Okay. It's premature, but
Yeah, that would be
I
procedurally.
know, procedurally, I don't know if I can
Yeah.
allow that if you haven't technically entered your appearance
I
yet.
understand, Judge. I'm offering that for the information for the court.
Thank you. And then, Board of Education of Pleasant Hill, CUSD number 3, I have an answer and no motion to dismiss. Anyone here from Pleasant Hill? Okay.
Their attorney is Mr. Yao, it looks like.
Oh, that sounds right.
So they answered with no motion, right, Judge?
Right, yes. They filed an answer, according to my notes, on July 7th.
Correct.
And then Redbud CUSD 132. I don't have an answer or a motion to dismiss. Anyone here for Redbud? All right.
Do you have an entry on Redbud yet?
I show an entry on April 12th of 22, so if you could look that up as well. And then, I don't know if it's the same attorney or not. Same thing for Mount Zion, CUSD number 3. I show an entry on April 12th, but no answer and no motion to dismiss. Anyone here from Mount Zion? Not you, Mr. Feeney? It's over in that area.
Nope.
Pretty sure that's the, that Sean Thompson.
Okay.
Oh, yeah, it is. Barney,
Barney Mundorf? Yeah.
Barney.
That's the same attorney judge that represents the Edwardsville School District in the...
In the 07.
Yes,
case,
ma'am.
right?
Yes, ma'am.
And then finally, I have Board of Education of Liberty, CUSD number 2. I have an entry of appearance from May 4th, but no answer or motion to dismiss. Anyone here from Liberty? That's Mundorf too? Oh, oh, sorry. Can you look for Liberty, May 4th was? Hmm? Oh, okay. My chair keeps falling apart up here.
Oh, is that the one? I think that's
We need some duct tape or something. As soon as that entry loads, we will let everyone know who that is. Oh, David Penn. He was the one who was trying to get on through Zoom, but
That's David at Liberty?
yes.
Yeah, that's Adams County. We should have known that.
Okay. And then everyone else, I either have motion, I guess I have motions to dismiss on everyone then, except Lisbon, just because procedurally. And then Redbud, Mount Zion, Liberty, and Central CUSD number 4. Nope, strike that. There's a motion to dismiss on that one. So just Liberty, Mount Zion, and Redbud, and Lisbon. Okay. Hopefully that's everyone. 146 defendants I have, counselors, but I lumped all the state defendants as one.
There's 146 if we, that would have counted the Hillsborough case at one time, I think, which is now, that's gone.
That's gone, but that was the 05 case,
Yeah.
which was voluntarily dismissed by plaintiffs, Your Honor.
Okay. All right. So who's going first? Are you, Mr. Kincaid, are you going to go first on the motion?
I'll go ahead and go first,
Okay.
Your Honor.
Let me get my correct piece of paper up here just a second. Do we want to, it's too late for that. I say, do we want to stop the transcript and start again? Do you want me to recall the case for the motions to dismiss, or I guess you can separate them anyway. Okay, go ahead, Counselor. I'm ready on the motions to dismiss.
All right, great. Melanie Rankin, again, for the 6 districts I listed earlier. I won't repeat them now, but.
Don't need to. We have that on file. Thank you.
Perfect. All right. So, Your Honor, given that plaintiffs have failed to respond to our motions to dismiss, or any of the motions to dismiss for that matter, we are essentially going to be resting on our pleadings for most of our arguments as to why this case should be dismissed. Namely, that, first of all, a significant number of plaintiffs lack standing, and that they don't even have children who have been excluded from school for not wearing masks or for being identified as close contacts. In addition, plaintiffs were served with, 45 of the plaintiffs were served with requests for admissions more than a month ago that they have failed to respond to. So they have deemed admitted the fact that they don't have children who have been disciplined for not wearing a mask, or who have been, again, excluded for not wearing a mask or for being identified as a close contact. They've admitted that there are no district policies in place that require any masking or close contact exclusion. So we will, again, rest on our pleadings for the standing argument. Second, the law of the case requires dismissal, going back to what we talked about earlier, or what was alluded to earlier, which is that the 4th District has already held that the IDPH Act does not apply to school district's orders. These distinctions without a difference, basically, good luck in arguing that to the 4th District, I would say, in terms of the fact that they're ruling that the school district's policies are not subject to IDPH Act applies equally whether it's an employer, whether the school district is an employer or an educator. The 4th District based its ruling on the fact that the IDPH Act authorizes people to be isolated and quarantined from the general public, and that the school quarantines don't do that. They don't require anybody to be isolated from the general public. They're simply telling people they can't come into the school for a period of time. And the school code, just as the 4th District pointed out, that the IDPH Act simply applies to the IDPH, and it doesn't preclude employers from making their own health and safety rules. It certainly doesn't preclude schools who have a statutory right to enact rules and policies for the purpose of operating their school district. They have a statutory right to do that. So obviously that reasoning applies even more so. The 4th District's reasoning applies even more so in the case of educating our kids and keeping them safe, because the school districts have that statutory right. Then thirdly, plaintiffs have failed to plead any actual or present threat of irreparable harm. Again, we'll rest on our pleadings in terms of that argument. What I am going to go into today, though, and take some time with, is to reiterate the basis for dismissal that a majority of the defendants have also presented in their motions to dismiss, because it goes to the heart of this court's jurisdiction, and that is the fact that this case is moot, Judge. It's moot, period. From the beginning, this case has been about challenging the state's authority to issue masking and close contact exclusion mandates and keeping the school districts from enforcing those mandates. Intervenors Council just reiterated that. This is all about the state mandates. There are no state mandates. There haven't been for going on 6 months now. And really begs the question why 145 school districts were brought into this to begin with, because everything's about these state mandates. Whether the state had authority to enact them, whether the state, exceeded its authority, whatever, the school districts have been bound by the state mandates regardless. So why we've been tangled up for almost a year now, as Mr. DeVore pointed out, he counted 17 attorneys here. Why? There are no mandates. The schools are under no mandates to implement any such policies, and therefore the issue is moot, and there is absolutely nothing plaintiffs can do to plead around that. I'm asking the court to consider this issue from both a legal and a practical perspective. Under Illinois law, an issue is moot if 1, there's no live controversy, and 2, if its resolution could not have any practical effect on the existing controversy. First point, there is no live controversy. Again, there are no state mandates, no local health department mandates, no district mandates. There are no mandates for plaintiffs to be opposing. There is no controversy. Second, there is no resolution of this lawsuit that would have any practical effect on the mandate controversy. If the court grants the relief that plaintiffs want, which is ruling that the districts cannot enforce mask mandates or exclude close contacts, the result is the status quo. No mask mandates, no close contact exclusions. We've submitted affidavits from every one of our superintendents stating they do not have policies requiring mass or close contact exclusions and have no intention of implementing any such policies. So by definition, this case is moot. And since this case is moot, this court does not have the jurisdiction to hear it. Any opinion that you issue would be based on hypotheticals such as, what about monkeypox? Are they going to do it with monkeypox? Or, well, they've got their hand on the trigger, they just have to pull the trigger, and who's to say they won't pull the trigger? But that is all hypothetical, Your Honor. There is no controversy right now. And any ruling on the merits of this case would be advisory, which is not allowed under Illinois law. Again, there's no way for plaintiffs to replead the lawsuit to create a controversy, because the only way they could plead this lawsuit into a live controversy is to plead that there are actually mandates, and there aren't. At the June 9th scheduling conference, and actually today, plaintiffs' counsel hinted that the public interest exception to the mootness doctrine applies in this case. But given the fact that he didn't file a response to the motions to dismiss and effectively waive that argument, I'm assuming he realized the narrow exception doesn't apply here. However, I'll go ahead and address it anyway since it has been brought up. There are 3 criteria for the exception to apply, and none of them exist here. First, the question has to be of a public nature. This isn't a question of public nature. This court recognized as much when it denied plaintiff's motion for class certification back in February. And while plaintiff's counsel has attempted to get as many plaintiffs as possible to sign on to this suit, the bottom line is any relief granted by this court would only apply to the named plaintiff's children, who by my calculations represent maybe about 1,000th of 1% of the school children in Illinois. Again, 1,000th of 1%, maybe, and that's erring on the side of being higher than the actual number. And let's not forget that plaintiffs haven't even pled that any of these children or each of the children has actually been disciplined or otherwise affected by the former policies. To be considered of a public nature, the issue has to be of sufficient breadth or have a significant effect on the public as a whole. The minuscule percentage of school children in Illinois who are represented in this lawsuit can hardly qualify as sufficiently broad or significant on the public as a whole. The second criteria for the public interest exception to apply is that an authoritative determination is needed for future guidance of public officers, such as in a case when the law is in disarray or conflicting precedent exists. Contrary to what counsel argued earlier, that's not the case here. In fact, the 4th District Court of Appeals has twice held that plaintiff's legal theory pertaining to the IDPH Act is wrong. There is no need for additional authority when the Court of Appeals has already rejected plaintiff's interpretation of the very law they base their claims on. Finally, for the public interest exception to apply, plaintiffs would have to show that the question before the court is likely to recur. The state mandates expired, and there has been no indication that they will be renewed. Again, the 4th District even held as such. By plaintiffs' own admission, the districts implemented their masking and close contact exclusion policies only because the state mandates required them to do so. And they rescinded those policies once the state mandates they were no longer required by the state to have those policies. Again, each of the superintendents testified by affidavit that they do not have masking or close contact exclusion policies in place and have no plan to reinstate them. Even if plaintiffs had responded to the motions to dismiss, they could not have gotten past this issue of mootness, and they cannot make a showing of any of the 3 criteria of the public interest exception, much less all 3 of them. The law requires dismissing this case with prejudice, but I would still like to take a minute to ask the court to consider the practical implications of allowing this case to proceed. The operative complaint is the 4th complaint that plaintiffs have filed in less than a year in this case. And now they're asking to file a 5th. When this court denied their attempt to certify a class, they amended around it by adding about 1,000 new plaintiffs to compensate for that ruling. When the state mandates expired and they were left without any mandate to sue over, instead of celebrating the end of the mandate, which is what they claimed this lawsuit was about in the first place, they filed yet another complaint in an attempt to plead around the fact that there was no mandate to protest. Then they just pled without any factual support whatsoever that the districts only temporarily rescinded their policies. After dozens of districts filed motions to dismiss based on mootness, plaintiffs asked to amend their complaint yet again before the court had a chance to consider the mootness arguments. Now they want to claim that mere guidelines that were announced more than a month ago are somehow unlawful. In other words, if the court does not grant the motions to dismiss with prejudice, this case could effectively continue into perpetuity, with plaintiffs filing a new complaint every time the state or a school district mentions the word COVID. If this were a matter of plaintiffs truly just wanting their children to be allowed to attend school in person regardless of whether they wear a mask and regardless of whether they've been exposed to COVID, they would have dismissed it on their own and claimed victory. Instead, they're intent on keeping the districts tied up in this litigation, spending time and resources defending a controversy that simply doesn't exist. One final thing. Given the time constraints inherent in a hearing that involves about 2,000 parties, I'm asking the court to take heart to the fact that plaintiffs failed to file any responses to the dispositive motions and to not allow counsel to use this hearing as a way to bypass the briefing schedule set in the scheduling order. If plaintiffs are allowed to present arguments today, then defendants would be entitled to an opportunity to brief their replies, which would mean plaintiffs have gotten away, once again, with completely disregarding an order from this court. Throughout this case, plaintiffs have ignored and disrespected this court's orders. When you gave plaintiffs a deadline of March 24th to file an amended complaint, they waited until 4:09 p.m. on that deadline to file a motion for an extension of time, obviously assuming it would be granted. Of course, plaintiffs had time to file TROs against specific districts in that meantime. They just didn't have time to abide by the court's order. When this court took notice after 6 months of litigation in this matter that plaintiffs still had not served all of the parties, you gave plaintiffs a deadline of April 15th to file notice with the court of what defendants had been served and what defendants still had not been served. That time, plaintiffs didn't even bother asking for an extension. They just ignored the deadline and didn't do anything. April 15th came and passed without any such notice being filed. The court's most recent scheduling order set a deadline of July 22nd for plaintiffs to file their responses. However, at 3:15 on July 22nd, instead of filing responses and without any legal basis whatsoever, plaintiffs filed a motion to vacate today's hearing and wait until defendants were required to respond to a fifth complaint. A fifth complaint, though no mandates have been enacted and no laws have changed since their fourth complaint. Allowing plaintiffs to present arguments in response to the motions to dismiss today would be granting them the very thing they tried to achieve through their attempt to cancel today's hearing, and that is to simply buy more time to keep this case alive for no justifiable reasons. It's time, Judge, it's time for this court to rule on our motions. It's time for plaintiffs to concede that there is no fight left that belongs in this court. And it's time for our educators to be allowed to get back to the business of educating. We're asking the court to please grant the motions to dismiss with prejudice. Thank you.
Thank you. All right, we didn't decide on a procedural aspect of this. Are we going to have all the defendants argue and then you reply? Because I think their positions are all the same.
Whatever the court desires, Judge.
Your Honor, Jerry
Yes, sir.
Kincaid.
Yes.
On behalf of the Attorney General, or I'm sorry, from the Attorney General on behalf of the state, may I make a suggestion?
Please.
I'm going to join Ms. Rankin's request that plaintiffs not be allowed to present an argument here today because they did not file a written response at the time that you ordered them to. There's a tactic, it's called trial by ambush, and it's been used over and over again in these cases. And it's unfair both to the litigants and to the court. So I would ask that you rule on that question first, because if you're not going to allow them to talk, it'll be a different presentation I put on than if you do.
Any other defendants have a position on what Mr. Kincaid and Ms. Rankin just, Mr. Klein?
Your Honor, William Picorni for a number of the defendants. We filed replies in support of our motions to dismiss, making essentially the same points, so we agree.
And I read those, yes, thank you.
Your Honor, Lisa Callaway on behalf of 30 of the defendant school districts, and we will join in Mr. Kincaid and Ms. Rankin's request that plaintiff's attorney not be permitted to respond because they failed to file a response to the motions to dismiss.
Good morning, Susan Nicholas from Robin Schwartz on behalf of 8 of the school district defendants. I will also join in the arguments made and the motions that oral arguments not be allowed under these circumstances.
Okay.
Morning, Your Honor. Reynolds Slade on behalf of 11 defendants. I'll also join.
Thank you.
Mallory Belusi on behalf of 2 defendants, and I join in the same.
I would stipulate that they all take the same position, Judge.
Can you state your name again for the court reporter?
Yes, Mallory Belusi, M-I-L-O-U-Z-Z-I.
Okay. So we'll put on the record that all defendants take the same position as Ms. Rankin and Mr. Kincaid, okay? I'm going to let Mr. DeVore respond to the argument that he not be allowed to argue.
Judge, there's no jurisprudence whatsoever that says I can't make a legal argument. Talk about what the law says or doesn't say. The point, even Mr. Picorni tried to bring up that the court has the ability to preclude even legal arguments, but the case he even cites to you has to do with motions to reconsider, and in a motion to reconsider, you can't create new legal arguments that weren't otherwise made when the other court otherwise made the other ruling. But the request to admit and things of that nature about those facts, I can't stand here in front of you and argue those. I understand that, and there's no dispute there. But to say that I can't argue the mootness issue or some of these other legal issues, I know of no jurisprudence that disallows that. Thank you.
Your Honor, briefly, as far as the new plaintiffs, we didn't have a complaint on file to respond to it. So I think procedurally it would be unfair to say that we can't participate in the argument when we just had we were just granted intervention a few minutes ago.
Judge, this is exactly what I was asking to not happen earlier, is his intervention now tying up or complicating what was already going on in this case. And so, no, he didn't have an opportunity to respond. He said he would be writing on, he would be accepting Mr. DeVore's arguments, responses. Mr. DeVore had no responses, so that's his response.
Well, what I said is I did not seek a new briefing schedule. I didn't want to hold things up, and that what happened to his complaint happened to mine, other than any procedural issues, which I reserved. And so we certainly weren't waiving argument, and I specifically said that we would argue in addition if there was anything we thought we needed to add.
Okay.
Thank you.
Your Honor, Darren Kincaid, Mr. DeVore said he didn't know of any authority that would allow you to stop him from arguing today. Well, I've got some authority right here. We studied this to you before, actually, in connection with Mr. DeVore. You may remember the last time I was actually here. Sorry, I told you, I warned you about that.
Are these arguments in the pleading, Judge? Because if not, he's vitiating his own position.
Well, Your Honor, these arguments were in the pleading that we filed back in October of 2020 in the county disaster case. And in that case, Your Honor, you may remember we cited this particular appellate court opinion to you. It's Parkway Bank versus Neseljevic, Neseljevic. The site is 406 Ill App 3rd, 435. And what Parkway Bank holds is that oral argument is a privilege, not a right. It's a privilege. And when counsel fails to file a written response to a motion, the circuit court has discretion to tell counsel, you may not participate in oral argument. And the reasons are those that I explained earlier. It's disruptive. In fact, we're all kind of witnessing the disruptive nature of this right now, compounded by the fact that no one on this side of the room received Mr. Walsh's pleading or reply in the other case. You recall how disruptive that was just a few minutes ago. So, Your Honor, Parkway Bank does give you the discretion to tell Mr. DeVore that he cannot present oral argument today because he did not file a written response. Thank you.
Anything else, Mr. DeVore?
No, Judge.
Okay. I'm aware of that case. When I was reading defendant's request to not allow them to argue, that automatically pops because in my head, because I always remember that oral arguments are a privilege, not a right. With regard to the cases cited, I do agree that it was with regard to a motion to reconsider. I cite those cases all the time in my motions to reconsider, that you can't frantically gather new evidence and try and present it at the motion to reconsider. We're at a different stage here. I understand defendant's position, but I am at the point now where I want everything argued and everything heard. So I'm going to deny the request. I understand your position, but I'm going to allow Mr. DeVore and Mr. Walsh to present their arguments, and then you can reply. If there is a necessity for defense to file a response of pleading after you heard those arguments, I will certainly allow it. If you are satisfied with your arguments, then we can state that on the record, and then we'll just go from there. But we'll address that once everyone's done arguing, if you want time to file something else, okay? Because I think that's only fair. And I do understand previously I had scheduling orders, and a lot of times I put on that scheduling order, failure to file a reply or response, you forfeit your right to argue. I looked, that was not on the scheduling order. So had that been on the scheduling order, I would have enforced that, but it was not on the scheduling order. So I'm going to allow counsel to respond.
I looked for that, Judge.
I did too.
Thank you, Your Honor. I can be very brief if you'd like me to talk for 2 to 3 minutes, and then whoever else has a...
Yep, go for it, and try not to talk so fast for the court reporter. I'm used to it, but I'm not taking everything down.
I've learned my lesson. I apologize. Your Honor, like I said, I'll be very brief. I know you read everything that we file in these cases, and when you picked up our brief that we filed here today, you probably thought this sounds familiar because
Yes.
it's very similar to the brief that we filed in the Foxfire case.
Yes.
And I don't know if you talked to Judge Minonia about these cases, but it's very similar to the brief that we filed in Moore,
Yes.
the case that you used to have about high school athletes. So, like I said, I can be brief. But
Okay.
I think the way that I can be helpful here is to make sure that we emphasize there are 2 separate issues that are implicated by our mootness arguments.
Okay.
2 separate issues. The first issue is this case moot? Is this case moot is question number 1. And that's an issue on which we, the defendants, have the burden of proof. We've got to convince you that the case is moot. If we do that, if we are successful in carrying that burden, there is a second question which arises, and that is, do any of the mootness exceptions apply? And that question, we don't have the burden on. We don't have to say anything about that, and we can still carry the day. It's plaintiff's burden to both raise those mootness exceptions and then convince you, not with speculation, but with clear evidence that each of the essential elements of that exception has been satisfied here. It's their burden to do that. And when I walked into this courtroom at 9 a.m., no one on plaintiff's side had even suggested that any of the mootness exceptions apply. That's because, of course, we had not received the reply brief filed in connection with the motion to intervene. That's their burden, to raise those and then convince you that they apply.
Okay.
So in terms of whether the case is moot, I join Ms. Rankin's argument completely. She did an excellent and very thorough job on that. The executive orders and emergency rule that did at one point compel school children to both mask and then get excluded, those have not been in effect since March. So the case is moot. And that raises the second question, do any of the exceptions apply? Now, I know Mr. DeVore will have something up his sleeve today, and you're going to let him talk. But I submit that there is nothing he can possibly say to you that can convince you to disregard the binding holding of the appellate court in this very case. Because the appellate court in this case, back in February, found that the public interest exception was not satisfied. And the reason why they found that, a question of law, is because they said it is not likely that the governor will reimpose any of the challenged executive orders or emergency rules. That is what they found back in February. That is a question of law, and you're bound to follow it. I cited that opinion to you in the Foxfire case. Back then, I was just citing it to you for persuasive authority because it's not published, it's not precedential, but it is possibly persuasive. I cited that to you in the Foxfire case, and I think you found it persuasive because you ruled in our favor. But in this case, it's a little bit different because it's binding on you. The appellate court said in this very case, the public interest exception is not satisfied because the challenge conduct is not likely to reoccur. That was in February. Nothing has changed since then. Now, I recognize that there are two other exceptions, right? But one of those exceptions, the capable of repetition, yet evading review, that exception, as you know from our Foxfire briefing, also requires a showing that the challenge conduct is likely to reoccur. So when the appellate court says it's not likely to reoccur as a matter of law in connection with the public interest exception, that question of law, you are bound to follow them when applying it to the separate question of capable of repetition. You can't find that either of those exceptions are satisfied without disregarding the appellate court's holding. And then there's a third exception too, but I don't think anyone has seriously suggested that it applies here. It's the collateral consequences exception. That really is about when you're seeking money damages. So you have some ongoing remedy that you want even though the challenge conduct is over. That's not an issue here. So Your Honor, I have nothing more to say on this. I'm happy to answer questions if you have any, or turn the baton over to someone else.
I do not have any questions for you. Thank you.
Thank you.
Anyone else want an opportunity to? Mr. Picorni?
Thank you, Your Honor. William Picorni for the Chicago Board of Education and 15 other school districts. We'll stand on our pleadings as there's been no response to the motion filed. I do just want to make two very brief points. And I certainly reserve the right after opposing counsel have an opportunity to respond to the motions orally to reply to whatever arguments they may make. First, substantive point, Your Honor, on the 615 motions. I want to read to you from your order denying the last motion for temporary restraining order in the Allen case. I believe this is your June 21st order. Following Glass, the IDPH and Certified Local Health Department have not ordered plaintiffs to do anything. The policy applies only to CPS employees, not to the general public. Accordingly, plaintiffs have not identified a readily ascertained right in need of protection. That was part of your rationale for denying the last TRO in the vaccination case in Allen. That same reasoning, however, Your Honor, applies with absolutely equal force here. Following Glass, IDPH and the Certified Local Health Departments have not ordered plaintiffs or their students to do anything in this case. The policy applies only to the students of the school districts that are defendants here. And again, to the mootness point that's been raised, those policies are not even in place in almost all of the school districts that are still before you. The policies that are being challenged have never applied to the general public. They apply only to the students in those schools. So according to the appellate court, according to those decisions that Your Honor the court is bound to follow, whether or not we agree with the logic of the appellate court and the interpretation the appellate court has adopted, those are binding decisions on this court. With respect to the mootness argument, Your Honor, the only other thing, I adopt the arguments, agree with the arguments that my co-counsel have raised. I just wanted to bring to the court's attention the Bixler case that's cited in our motion to dismiss on behalf of the districts that we represent other than Chicago Public Schools. This is at page 6 of our memorandum of law, and it's Bixler versus Illinois State Board of Elections, 2021, ILAP 4th, 200-458. This is a case that was dealing with changes to the election code related to COVID-19. I know Your Honor is familiar with the case. And again, that case speaks to the fact that, look, even though the pandemic is ongoing and there may still be further issues arising related to COVID-19, that doesn't mean that the claims are not moot, because the policy that was at issue in that case was no longer in effect, and it was pure speculation that those issues would continue to occur in the manner that they were being challenged in that case. Exactly the same logic applies here, Your Honor. The plaintiffs present no evidence that any of the school districts that have moved to dismiss on the basis of mootness have any intention or are likely to reimpose any of the policies that they're challenging in this case. Mr. DeVore has acknowledged that plaintiffs have waived their opportunity to present any contrary evidence to that fact. The affidavits and the evidence in the record is uncontested. So on that basis, Your Honor, we ask the court to grant the motions to dismiss on the basis of mootness, as well as the 615 motions. And again, we'll rest on our pleadings, subject to any further arguments that opposing counsel may wish to make.
Thank you.
Thank you, Your Honor.
Anyone else?
Your Honor,
Mr. Feeney?
Luke Feeney on behalf of 11 districts, and I may be able to speak for the remaining attorneys. For those of us who are also standing on our pleadings, we'd just like to reserve the ability to present in rebuttal after plaintiff's counsel goes, as we still are in movement, but I don't need to say anything at this time.
Okay.
Good morning, Your Honor. Robert Swain on behalf of 11 going on 12 school districts here before you. And we, of course, have joined in the motion and joined in the argument of our colleagues here. But I want to speak for a couple of minutes because I thought fairly deeply about some of the 615 implications. I think about how the court might rule here on the issues that are before the court. And then, of course. Some of these issues, I think, come back to even implicate some of the questions of whether the case is moved in the first place. But from a 615 perspective, I think we have serious difficulties in trying to go forward with the case as it stands, by which I mean, we are, of course, standing here in Illinois in fact pleading jurisdiction. And we have operative complaints, even the pending amended complaint that's been filed, that don't include any individualized allegations against any of the individual school districts that are before you. Now, when we were here in January, that really wasn't a concern. Because in January, we had statewide mandates in effect. We had emergency regulations from the Department of Public Health that were in effect. Those mandates, those emergency regulations required school districts to adopt specific mandates locally. Okay, we spent many hours discussing those. Okay, and by force of law, effectively, the policies and the actions of all of these school districts were effectively identical. But for many, many months now, we have not had statewide mandates. The emergency regulations expired a long time ago. That, of course, is the reason why the 4th District decided that the TRO itself was moved by the time it reached their desk. We have not had statewide mandates since spring. And as we stand here now, none of these school districts have adopted mandates, as you've heard, but more specifically from a pleading standpoint, even if some of these school districts decided to adopt local mandates, again, going to some of these maybe mootness considerations, we have no way of knowing what any one given school district might do. This is not a simple black or white, yes or no question. There are different types of mandates that might be considered and adopted in different districts. There are different requirements that might be imposed. It might be masks required for everyone in the building. It might be masks required for close contacts. It might be masks required for symptomatic individuals. It might be masks required in the nurse's office. There are many permutations of each of these concepts that might be considered and imposed locally if, again, getting back to the mootness point, any of these occurrences do actually repeat. Again, touching back on some of the mootness considerations. But unless and until that happens, mootness considerations.
Or considerations.
But unless and until that happens, we have no allegations in any of the complaints identifying which school district has adopted any particular mandate and what its specifics might be. And so we are left, I think this also is then going to kind of connect with some of the frustration you've heard from some of my colleagues. We have operative complaints that simply have broad, sweeping, factual allegations saying every one of these school districts is doing this same thing, fill in blank over several paragraphs, putting the burden on these 146 school districts to prove 146 negatives. That's the opposite of how fact pleading works. And unless and until we actually have pleadings that said, one of Mr. Swain's school districts has adopted this policy with these specifics, which then violates these requirements in this way, it's very difficult for me to contemplate how the case would even go forward.
Okay,
Thank you.
thank you. Any other defense counsel at this juncture? All right, with that, let's let Mr. DeVore respond if you would like.
Yes, ma'am. You know, my esteemed colleague, Mr. Swain, came pretty close to making one of my arguments for me, Judge. He talks about these general pleadings and these broad questions and broad requests from the court as it relates to my client's documents. But hasn't been mentioned by any of the defendants is that they're asking you to do the same thing. Each one of their motions to dismiss asks you to dismiss the complaint. Doesn't ask to have their school district dismissed. That would have been an interesting argument. Would have even been a more interesting argument when my colleague stood up here first and said this only has to do with the state mandates. I wonder if she's prepared to stipulate to the court as part of her dismissal that her clients lack any inherent authority under the school code to do any of that. Because if it's only about the state mandates, then that would seem to be a reasonable stipulation of law. I bet they don't want to do that, Judge. So there's two issues going on at the same time as it relates to the case. One, state mandates, the governor, the administrative agencies. Then you have the school districts. When this case first came in front of you, it was dealing with state mandates. And then interestingly, what we found ourselves seeing is that the school districts weren't talking about the mandates. They completely ignored it, talking about inherent authority. So this case has developed as times went on. And when Your Honor issued the scheduling order, I believe June 9th, wouldn't you know it that very shortly thereafter, we get new issuances from the Department of Health / State Board of Education. Now my colleague says to you, that's guidance, Judge. That's guidance. But the pleadings in this record, based upon our motion to you, which will be heard in a week, and that list is growing, of school districts who are now implementing the guidance. So the argument that we'll get to, I'll jump around a little, Judge, because you know this stuff as well as we do. The argument of the Allen or Glass case, we're just talking about Allen. You know, when they're talking about that case, it doesn't apply, or it should apply here. I'd ask the court to read that case. Because the very last sentence says, based on the specific facts and arguments in this case, what is that? Workplace safety. We're not requiring anything of people outside the workplace. And I agree, maybe counsel for the state said it's a precarious question that dealing with vaccination and testing, but so be it. That's what the case said, Judge. But that case saying that, well, think about this, Judge. There's a Rule 23 order specific to that case in Allen. Is it binding on you in this case? Rule 23 in a separate case says specific to that case? I don't think so. But in that case, again, it was vaccination and testing, and they said that the health department wasn't doing it, and it was a school district. And I think you even push back on that reasoning a little bit in one of your orders in the other case, but as it relates to vaccination, or to masks and exclusion, Judge, we have an extra caveat. We have administrative rule that specifically considers quarantine to be exclusion from school. Excluding a child from school, a type of quarantine for the supreme authority of the health department. Then we have a health department who has issued, since this scheduling order, lays out this guidance, and the court's probably read it. It's in the record. If you're a close contact and you're not vaccinated, you go home for 5 days. You come back 6 through 10, you got a mask on. So is this court going to say, well, it's the school district doing it, and they're not following, it's not the Department of Health doing it, so it makes it okay? I mean, I try to wrap my head around that, Judge, and it's almost, with all due respect to the appellate court, I don't get it. But Rule 23 in that case is not binding on you. Getting back to what they're asking for the case as a whole to be dismissed. There's no case in controversy. There is a case in controversy, Judge. Again, is there a case in controversy as to each and every one of these individual defendants right now? That's a separate question when you look at their pleadings asking you to dismiss the whole thing with prejudice. How can Mr. Swain's clients ask you, I just picked Mr. Swain, so I know him best, ask you to dismiss a whole cause of action with prejudice? Those other defendants, and you've known them off, Judge, some of them have filed an answer. How do you say there's not a case in controversy if you have some of the defendants that filed a responsive pleading?
Time's up now.
Did you do that, Mr. Berticchio?
Not me.
Yeah. Again, procedural, I think we can all sit here and go through that in our head. One plaintiff, one defendant. This case is obviously more complex. My colleagues would probably blame that on me. I blame it on the governor. But some of them have entered their appearance and they've not filed a responsive pleading. Do they have the right as co-defendants to ask you to dismiss it for them too? I don't get that, Judge, and again, I don't think that's even proper. Is this case moot? Again, we're arguing it's not moot because there is a case in controversy, especially now with the new guidance that was issued since you issued the scheduling order. That's why we're asking to amend. But let's cut right down to it, because I imagine people are watching and listening to all this legalese. It glosses the eyes. Kids are going back to school in week, 2 weeks, etc. And school districts and the governor probably desperately want this case to go away. And then, where does that leave? What's practically going to happen, Judge? And you should consider this with your mootness argument. What's practically going to happen? I think Mr. Corney kind of mentioned it, is that the case is gone, school districts start doing all kinds of stuff. And he's right. Are they going to adopt the CDC/IDPH ISB guidance in some fashion? They're going to do some hybrid of that, etc. Right. Are they going to adopt the CDC/IDPH ISB guidance in some fashion? They're going to do some hybrid of that, etc. Right. Are they going to adopt the CDC/IDPH ISB guidance in some fashion? They're going to do some hybrid of that, etc. right? Are they going to adopt the CDC/IDPH ISB guidance in some fashion? They're going to do some hybrid of that, et cetera.
in nature. Again, with
In some fashion, they're going to do some hybrid of that, etc.
in nature. Again, with the Austin decision, or the Allen decision, rather, Your Honor, in 5007, Mr. DeBoer commented that at the end of that decision, signals to litigants, and that was a signal that this decision is reserved for this set of facts. And I would argue, again, it's reading tea leaves, but that's a signal for the other cases like 5002. Mr. Picorni brought up the Bixler case as being representative of this. In the Bixler case, the issue was whether the collection of signatures was being impacted by stay-at-home orders. And I think after the end of the stay-at-home orders, the court rightfully found that that was unlikely to be repeated. That really has very little value in this case. The governor is issuing mandates as we sit here today, or has a current mandate in effect. So I don't think that case is very analogous. So with that, I will rest. Thank you, Your Honor.
Okay. Thank you. Mr. Feeney is jumping at the chance.
I made the mistake of leaning forward here. I had to sit back instead. I'm happy to go first. I'll be brief, Your Honor. 2 points. In terms of the propriety of the pleading, the prayer for relief in both our 615 and 619 motion, paragraph B, dismiss the school districts from the present case. School districts is defined in the motion as the 11 units. We are absolutely requesting that you dismiss those 11 school districts from this case. Whether the case remains beyond that, separate issue, but we are absolutely asking for dismissal, and that's in the pleading.
Okay.
In terms of the Allen case, we've cited that as a Rule 23 opinion. We're not stating it's binding. We've called that out in the motion. However, the Allen opinion is not a random Rule 23 opinion in the sense that in this very case, without objection from any party, we agreed day one to incorporate the TRO proceedings in Austin and Allen. And I believe Mr. Reticchio said, Your Honor, none of us are going to remember in which case we made which argument. And why did we do that? Because the arguments in the two cases are exactly the same. The only issue that this court needs to decide is this an action taken by the public health department? The appellate court has said no. It is the same argument in this case that it is in Allen. Thank you.
Thank you. Ms. Reagan?
Your Honor, I just have a couple of points in reply to counsel's response. First of all, to the extent that he argues that we need to each plead our own or file our own motion on behalf of our own districts, asking only that our districts be dismissed, I'd like to remind you that mootness is a matter of subject matter jurisdiction. So it goes to the heart of whether this court can even hear this case. And subject matter jurisdiction is something you can raise on your own authority, on your own initiative. You certainly don't need any of us to do so. Secondly, I'm really baffled. I don't understand plaintiff's argument or counsel's argument about requiring my districts to come in here and say they don't have authority to have masking policies. That's not what we're arguing here. We're saying they don't have masking policies. They don't have close contact exclusion policies. There is no controversy. I have to say this is the first time in my practice that I've heard plaintiffs' counsel repeatedly assign a nefarious motive to defendants, basically giving them the relief they wanted, which is no more mandates. But he keeps stressing like, oh, it's just a coincidence that there's no more mandates. Like, I'm really at a loss as to what he's implying here. You know, I mean, there are no mandates, period. They got what they wanted. Does it matter the reason they got what they wanted or what have you? There are no mandates. There is no controversy. I'm also, in terms of counsel's argument or suggestion that there's no Supreme Court case or to the effect of vaccines being a matter of employer safety rules, I actually am, I would have to say he hasn't tried then, because there are numerous cases that have come out of this very Supreme Court, as we all know, which is exceptionally conservative, that have upheld vaccine mandates in that employers have implemented. And in fact, the guiding case for vaccines for everyone's edification is from 1915 that the Supreme Court is still following, which says it's a Jacobson versus Massachusetts. I can get you the site later, but
I know what it is.
yeah, I mean, it's like you can require an entire community to quarantine and stay in their houses or get vaccinated. You know, you can require a whole community to get vaccinated. So I'm not sure, if that was just an off-the-cuff argument or if he truly believes that there is no such legal authority. And then again, when he refers to the 4th District's opinion in Austin, saying that it has nothing to do with this case because it applied to a TRO and it's not applicable, the court specifically said, because the emergency rules voided by the TRO are no longer in effect, a controversy regarding the application of those rules no longer exists. Those rules are no longer in effect. Therefore, a controversy still doesn't exist. So I'm not sure of the distinction plaintiff's counsel's trying to make there, but I would certainly stand on my argument earlier that it is the law of the case, that the rules aren't in effect anymore, the case is moot, and the public interest exception doesn't apply. Thank you.
Thank you.
Hi, Your Honor. Darren Kincaid for the state again. Mr. DeVore said something really extraordinary. I'm so glad that we have our court reporter here to take it down. I'm going to try to quote it back to you.
Okay.
I don't think we're going to see any statewide mandates from the governor anytime soon with respect to the mask mandate and the exclusion requirement that are issued in these cases. He said he doesn't think we're going to see any of those statewide mandates anytime soon. That means he's conceding that the conduct is not likely to reoccur. And because likely to reoccur is a requirement, an essential requirement of both the public interest exception and the capable of repetition exception, that means that he cannot prove that either of those exceptions apply to my clients. I didn't hear a lot from either counsel about my clients, by the way. Most of what they said pertained to school districts. I do want to clear one thing up, similar to Mr. Feeney. When Mr. DeVore said that we had asked for the entire case to be dismissed, I was a little surprised. So I looked at our motion.
Not the state. Not the state.
Oh, he concedes not the state, yes.
Sorry.
Thank you, Mr. DeVore.
Yes, sir.
We've only asked for the case to be dismissed as moot as to our clients, the state defendants. And Mr. DeVore concedes that, and I appreciate it.
Correct, sir. Sorry about that. I should clarify.
Now, there's one final issue that I want to raise, and that is the question of the new guidance, operative word guidance, just recommendations and suggestions from the state that may or may not be implemented by the school districts going forward. I think it's clear, if you read it, and it's attached to various documents that have been filed in this case, it's also available on the internet, and you can take judicial notice of it. I think it's clear if you read that guidance that it's not binding on anyone at all. If you, school district, don't want to follow it, you don't have to. If you, school district, conclude you can't follow it because you don't have authority to, you don't have to. It's, from the state's perspective, purely recommendations. We think this would be a good idea, but if you disagree with us, that's fine. You can do it your own way. And there's nothing unusual about that at all, Your Honor. It happens all the time. I went to a little diner near my house the other day, one of those old school hole-in-the-wall type of places. And on the menu, the big menu that I got with all the burgers you could order, down at the bottom in big red letters it says, IDDH recommends that you do not consume meat that has been not fully cooked at a certain temperature, right? I mean, it was all printed on the menu. I'm serious. I saw it. I thought, it's funny because that's exactly what we're dealing with in this case. It's just a recommendation. There are people at that diner and all over the state ordering their burgers cooked however they want, and just because IDPH thinks that you should do it a different way, that doesn't mean that you've been injured anyway. You can still get exactly what you want. And that's the issue here, Your Honor. The new guidance from the state, no one would have standing to challenge the state with respect to that guidance, because no one can say that that guidance injures them in any way. No one actually is compelled to follow it. It's purely advisory. So again, whether the school districts implement it or not, that's up to them. And whether there's a case or controversy with respect to their authority, that's separate. But there's no case or controversy with respect to the state pertaining to the new guidance or to the old guidance. As Mr. DeVore said, it's over. It's morning again in America. So we're done with this, from a state perspective at least. And for that reason, the case is moot. He admitted none of the exceptions can apply, and it should be dismissed as to our clients. Thank you.
Thank you.
Your Honor, I'd just like to briefly state that, as Mr. Swain pointed out, and Mr. DeVore seems to say, well, all school districts can just show up and show their policy. That's Mr. DeVore's job in a fact pleading the state. And in fact, every defendant showed up, or at least that's here, and provided an affidavit showing its policy that there is none. And until he actually has a complaint on file that specifically pleads those facts, he should not be allowed to argue them here that they might be put the burden on us, because that's his job. And to suggest otherwise, that 146 school districts show up and do his job for him when he can look up himself and actually file a real complaint that meets the legal standards in Illinois, it should not be on the defendant's job to do it, even though we did it in this case. So even if it's a general statement that should be dismissed, you could certainly find that all of the defendants that filed the motion to dismiss can have their defendants dismissed out and make Mr. DeVore come back in here with a complaint that actually shows that those 146 districts actually have a policy in place that requires masking or close contact exclusion or whatever else he thinks violates due process, and that they're actually doing that to those named plaintiffs, because that's not in the complaint before you.
Okay.
And could I get a name? Mallory Maluzzi, as stated earlier.
Good morning, Your Honor. Randall Slade on behalf of 11 districts. I have just one point I want to make, build on the state's argument about guidance. In connection with our motion to dismiss, we submitted 11 declarations to the superintendents of the districts I represent. Each one said roughly the same thing. We are not enforcing a mask mandate. We are not excluding close contacts. Those affidavits, if you look at the date, and I question whether the guidance is even appropriate to discuss because it was not submitted as part of a response, and Mr. DeVore's motion for leave to amend is not before the board today. Those declarations, at least for my 11 superintendents, were all filed after, signed in, and submitted after that guidance came out. So in other words, my superintendents reviewed the guidance, agreed with Mr. Kincaid's position that these are not binding on our districts, and we're going to go with the policies that we've chosen, which are outlined in the declarations, which have not been rebutted and are accepted by this court as true for this case. Thank you, Your Honor.
Thank you. Mr. Picorni?
Senator Williams Corney again. Just a few brief points. First of all, I agree with the points my colleagues have raised, and we adopt those. With respect to the 619 motion that we filed on behalf of 15 of the school districts that we represent, I just want to make clear, as my colleagues have, that with respect to the mootness argument, our argument is that the complaint should be dismissed as to those districts. We presented affidavits from the superintendents. As with Mr. Slade's affidavits, I believe those were dated after the guidance was issued, and plaintiffs have not presented any evidence to contradict the affidavit stating that those districts aren't enforcing masking and exclusion as challenged by the plaintiffs and don't have any plans to do so. So again, our position is not that the entire complaint should be dismissed as to districts that have not argued mootness. It's that it should be dismissed as to those districts that have presented that evidence to you, including the 15 that we have filed for on that basis.
Okay.
With respect to the guidance that the state has issued, again, it is guidance, and it's the plaintiff's burden once the defendants have presented evidence that the claim is moot. It's the plaintiff's burden to come forward with evidence to contradict the evidence that the defendants have presented in their 619 motions. There's no evidence before the court that any of the school district defendants have changed course from the position identified in their affidavits that they are not enforcing masking and exclusion as being challenged by the plaintiffs in light of that guidance. And so absent that evidence, the court should rule based on the record before the court, and it should find that those claims are moot. And lastly, Your Honor, I won't belabor the extensive arguments that we have had throughout the course of this case on the 615 argument as to the applicability of the IDPH Act. Except to say that Mr. DeVore says, well, the defendant's position is that if the school districts are doing it, it's okay. If the IDPH is doing it, it's not. That's exactly what the appellate court said. That's the reasoning the appellate court adopted, and the appellate court explained that reasoning. It's because of the plenary power that the Department of Public Health has under the IDPH Act, that there are additional due process protections that apply when it's the Department of Public Health adopting a quarantine order, as opposed to a rule that is put in place for workplace safety, or in this case, Your Honor, let's keep in mind that the rules that our districts, many of them formally had, but the rules that are being challenged in this place are also workplace safety rules. There are teachers working with these kids, right? So this artificial distinction between that's a workplace safety rule versus something else, that's not something that appears anywhere in the IDPH Act. It's not something that the logic of the appellate court's determinations has turned on. The issue is it the Department of Public Health acting pursuant to its broad quarantine powers, or is it simply another body of government adopting rules within the scope of its own powers in order to protect the people that it's responsible for? In this case, as the appellate court recognized in the Allen case, protecting students and employees. And finally, Your Honor, I just want to point out that even if the court concludes that the appellate court's ruling in the Allen case, the Rule 23 order in that case, is not binding precedent on this, for the Glass decision that preceded that ruling is in fact a published decision of the appellate court. And the logic of that case is absolutely binding precedent that this court is bound to follow. So again, I adopt the arguments that my colleagues have adopted, and other than that, we rest on our pleadings. Thank you.
Thank you.
Judge, Plaintiffs' counsel referred earlier to how all of these districts were starting to implement these policies, and so I'm looking at the policy that he attaches to his proposed third amended complaint, which I just want to verify that this is the actual portion of the policy or handbook that he's referring to that he deems objection. Diseases. The school will observe recommendation public of health regarding communicable disease may be excluded from school or be sent home from school following notification of the parent or guardian. Again, students with a communicable disease. The school will provide written instructions to the parent or guardian regarding appropriate treatment for the communicable disease. And 4, a student excluded because of a communicable disease will be permitted to return to school only when the parent or guardian brings to the school a letter from the student's doctor stating that the student is no longer contagious or at risk of spreading the communicable disease. If this policy is unlawful, God help us, because I would hope that every school district has a policy saying that if your child has a communicable disease, they shouldn't come to school, and they're going to be excluded from school. The state of Missouri has a statute saying they're not allowed to come to school. I don't know if, I'm sorry, I can't say if Illinois has that same statute off the top of my head. But the school, again, going back to these new guidelines that were issued in June of this year, if that's what Plaintiffs' Counsel is referring to, this is basically nonsense. The school will observe recommendations of the IDPH regarding communicable diseases. If that's what we're saying is unlawful, we're going to have a whole lot of lawsuits coming down the pipe. things.
Is it time, Judge, for me yet?
It's our reply, right? So there isn't a reply to a reply.
They're creating all kinds of new issues now, though. I understand.
To a response we never received.
You brought the issue up.
You just brought up pleadings that you said court shouldn't consider.
I do believe counsel behind Ms. Rankin was wanting to speak.
Susan Nicholas from Robin Schwartz, and
Thank you.
for purposes of clarity, our perf relief requests that the complaint be dismissed with prejudice with respect to our clients. I did not research the authority of anybody to file a motion on behalf of someone who was not our client because I didn't anticipate that argument. But presumably, if anyone is in that position, they should have the opportunity to reply. However, I do believe that it's clear in many of our motions, it's with respect to our individual clients. Beyond that, without trying to get too far into motions to amend, I will ask that the court focus on what's in this record and in these motions. And with the affidavits that were filed by many of my co-counsel, but also by us, the guidance that's being referenced is not relevant. It has nothing to do with this, and there's no pleading that can be filed that will correct this problem in the plaintiff's pleadings.
And did you have 30 districts, you said?
No, I have 8.
8, sorry. Who has 30? Someone has 30. I'm sorry.
Yeah, Lisa Calloway, and this has been sufficiently argued, I think, by my colleagues, and I'm appreciative of that. I will make the same statement, and I'm just going to ask all of the council here, I'm going to assume that all of our pleadings are specific to the school districts that we represent. So,
Well, I do believe the introductory paragraph of each pleading references your client.
yeah, and I believe we're all in agreement, so rather than us all have to step up and make that argument, I'm going to be making it with council's permission on behalf of all of our clients.
All right, thank you. Any other defense counsel? Anything else? Nope. Okay. I'm going to take the matter under advisement. I will issue a written order before our hearing that is scheduled next week, whatever date that is. Oh, it's not next week because I have a trial the week after that. I will email out my order, so Mr. DeVore.
I'll check, Judge.
Let's communicate.
Yes,
to
ma'am.
make sure that you are receiving my emails. And anything else that needs to be addressed this morning before we adjourn? I do have. Oh, it is next week? Oh, after the trial. Okay, sorry, next Thursday. Is that the 18th? Okay. So I guess I have to work.
Your Honor, just to confirm, is the hearing on the 18th here in person?
I thought it's by Zoom, but let me look. If you want to come down, you're more than welcome, but I do have Zoom on my calendar.
I would prefer Zoom, Your Honor, but thank you.
I do have Zoom, so same login information that everyone always has. And again, if anyone ever loses it, I have made that accessible on the circuit clerk's website. You go under information, under judges, and then my courtesy copy order is on there, and then my remote hearing instructions is on there.
Just a question, Judge. Should the court in this particular issue dismiss with leave to amend, would it vitiate the need for having that hearing on that day?
I would think so, yes.
Yeah, okay. So if that's what happens, you'll...
Right.
Okay.
Okay.
Judge, may I, really quickly, Lisa Calloway, we'd request that whatever your order is, that it be certified for interlocutory appeal.
Okay. Certainly.
And, Your Honor, we join that for our clients. It may be appropriate to just ask all the defense counsel if they join.
We join.
Anyone who does not join, please say so now.
Your Honor, I'm going to be an optimist. I think you're going to dismiss the case, so it's not going to be necessary.
Well, certainly as to the state parties, because they just gilded the lily that guidance is completely irrelevant. So I appreciated that.
I don't think I gilded any lilies, but
You did.
we'll leave that be for now. Maybe we'll address that next time.
If you did not sign the attendance sheet, please do so before you leave. If you know right now, if you want a transcript, please so indicate. That doesn't mean you can't do it later. Do you have cards you can hand to the defendants? You can get a card of the court reporter if you want that, if you want to make up your mind later. But thank everyone, and for those of you who will be around this afternoon, I'll see everyone at 1:30, for some of you. Court's in recess. I don't know who.
That was huge. That was perfect.
Sorry. Thank you. I can't answer that question. It's the 07 case.
Kids are safe together.
Same to you, of course. I appreciate you laying out so thoroughly.
Yes.
I really appreciate it.
Yeah, if you are going to be here this afternoon, if you want to leave your things, I can have the officers lock the courtroom and you can leave them in the courtroom.
Yeah, I need that transcript. I only need that part of that.
You want the transcript?
Yeah.
This is the birthday. She's coming.
I don't know. Are you here this afternoon?
Sorry, I don't.
Okay. Because she was wondering if she was here this afternoon. I said, I don't know.
No, thank you.
I guess if you would just verify your address is correct on that sign-in sheet, we're going to give her a copy of that.
You're not on there.
I'll just add it at the top. Okay, thanks.
We try to get them all on there, but working.
There's a lot of defense.
Yes. We about lost our mind a few times.
I can imagine. I can imagine.
And then one time we were doing this because we had entry of appearance, and I was losing my mind because we could not find him as a plaintiff. And then we realized it was in the 2022 7 case, not the 2107 case. Took us a while to realize that. I'm like, that's why we can't find him.
Thanks, Your Honor. Do you want all my information?
You can give it to
Just
her.
give her, okay.
I don't think you're on there.
Okay. Make sure.
I lied.
Okay. I'll
You were
sign.
right there.
Okay, thanks.
I lied. She was there.
Okay. That's Moonaka. Oh, right here. Thank you.
I lied. She was there.
What time is it going this afternoon? But that's on the companion case, right?
It's on 7 case.
7 case. Okay.
It's on.
Is that that?
It's not Austin versus Board of
It's not Austin, that is my Allen case.
So I think
Okay.
I'm only here for this morning then. Okay.
Thank you so much.
I wanted to make sure it was clear. I'll get you a new copy. Oh, yeah. Other people, I was intending to watch your